Thanks for staying with us, everyone. I'm Lynn Doyle, and this is It's Your Call. Before the break, you heard from Larry Mente's attorney, Julia Morrow, who explained why she has filed a post-sentencing motion on behalf of her client. Now, for reaction and to examine some of what she just told us, we're joined by Jeff Lindy, an attorney who served as an assistant U.S. attorney in Philadelphia and also as an assistant district attorney in Brooklyn, New York. He is the sole practitioner in the law offices of Jeffrey M. Lindy. Jeff, it's good to have you with us.
Thanks for having me back.
All right, so in a nutshell, what do you think? Where do we start?
I think Mr. Mendte has a uphill battle, actually, even to get a hearing in this case. The judge is Judge McLaughlin, who is a very fine federal judge, also very kind, very much a judge who likes to hear both sides and likes to give all parties an opportunity to be in her court. I think that Larry has a pretty good chance to get a hearing. 90% of the other judges in that courthouse wouldn't even give him a hearing.
Well, let's talk about some of the specifics.
Sure.
You heard Ms. Morrow talk about the proffering session, wherein a defendant comes in and provides information in the case.
Right.
But she's alleging that perhaps he self-incriminated himself by offering too much information or by giving them information they didn't have, which then they subsequently, she alleges, used against him.
Right. That's Larry can join in a long line of criminal defendants who have been convicted who are saying that something happened in the proffer that was unexpected to them. The whole point of a proffer is an offer of proof, so it's a very fancy lawyer term. All it means, it's a conversation where the criminal defendant and the lawyer come in and meet with the government and meet with the agents and the prosecutor, and they offer evidence. The whole idea of a proffer in a situation like this is that the client, the defendant, is doing a mea culpa. And the reason is, in a case like this, the government's got the whole case sewed together before they even come in for the proffer.
But what about the allegations that there were holes in the case that got filled as a result of what he said in his proffer?
Nonsense. In this particular case, they had all of the evidence from the keystroke. They had Alicia Lane's evidence that she provided. This is not a complex wiretap case. This is not a complex mob investigation. This is not a sophisticated white-collar fraud case. This is about as garden variety as an illegal wiretap case as you can get. And when Mike Levy, who was the prosecutor, sat down with Mendte and with Mente's lawyer, Michael Schwartz, I guarantee you that they had all the evidence they needed. All right? The government conducts about it's hundreds of proffers a year. Hundreds. They know the rules of the road.
Now, I watch Law and Order,
yes,
as I'm sure do many of the people who are watching, and we always hear when a defendant is ready to accept a plea that he allocutes.
Yes.
He essentially gives the details. Is that the same idea as proffering?
No. What happens in an allocution or a change of plea, which is different than Law and Order, is that Law and Order has a half an hour, right? Judge McLaughlin does one of the most thorough change of plea hearings in the courthouse. It's close to an hour. That means for an hour, Mr. Mendte and his lawyer were sitting in front of the judge while the judge went through question after question. Do you understand what the deal is? Do you understand that the government can do whatever they want at sentencing? Do you understand that these are the charges? Are you sure you want to plead guilty?
So wait, the judge was part of this proffering session?
No, the judge at the change of plea.
Oh, okay.
At the change of plea goes through a laundry list of questions, after which there is no doubt but that the defendant knows exactly what he's pleading guilty to, that he doesn't have to plead guilty, and that if he wants to not plead guilty, he can absolutely go to trial.
I should point out that now in this segment of the show, we do have a response from the U.S. Attorney's Office, which is also mentioned at length in this post-sentencing motion. And essentially, the U.S. Attorney's Office is saying they have received it. They have no additional comment at this time. Not unexpected.
No, they never talk about anything.
But yet they do comprise, it does comprise a huge part of this filing. Allegations of, how would you describe the allegations? Well, look, since you're the attorney.
Look, this can be boiled. Unfortunately for Larry and his lawyer Julie did. I mean, I read this. This is very well written, and it's compelling if you don't know the full context. I mean, so she did about as good a job as you can do, given the facts that her client gave her, and her client gave her terrible facts. Because what happens in a proffer is that you are told not what the charges are going to be. You were told that the charges could be anything. And specifically, what the prosecutor says to the defendant is, you are here to talk to me voluntarily, and we are not promising you anything. That is standard operating procedure.
Okay. Talks about the Fifth and the Sixth Amendment and alleges violations of both of those. Talks about perhaps inappropriate cause for federal charges as opposed to misdemeanor. Says, in fact, that it was extensive media scrutiny and coverage that perhaps prompted the U.S. Attorney's Office.
That might have been.
To follow through like this. You've been in a U.S. Attorney's Office.
That might have been. Look, you know, I'm not saying this was a wonderful prosecution, but you know what? Unfortunately, I don't get to decide who brings the charges. The government does. It's called prosecutorial discretion, and they decided for whatever reason to bring the charges. So that's water under the bridge. Fifth Amendment is the right not to incriminate yourself. When Larry went down to the proffer, he already gave up that right. The Sixth Amendment is ineffective assistance of counsel, and to say that the defense lawyer, Michael Schwartz, was ineffective, you're going to have to say that he did something that a reasonable attorney would not have done, and that's just not true in this case. I mean, there's an additional problem here also. If you want to really throw the harsh light of reality on this, is that the prosecutor is Mike Levy, the defense attorney is Michael Schwartz. These are two people who are very well known to the courthouse, and the U.S. Attorney's Office has a lot of different people, and I'm not saying everybody is equally as good, but these two people have the reputation of being as honest and as forthright as anybody else in that office.
Okay, let's talk about reputations, because Larry Mente's attorney has said that he is trying to reestablish himself, to return to a career that he was part of for 30 years.
He should have gone to trial.
Do you think this is the right course of action to try to get back into the business?
He's got no other course of action. He pled guilty. He didn't file an appeal, from what I understand. So I don't even think this is. I mean, again, I think Judge McLaughlin might give it a hearing because she is such a thorough and compassionate judge. But most judges, I don't think, would give it a hearing because he didn't even file an appeal. If Larry Mendte,
why would you file an appeal? He admitted what he did.
Because when he went, he already pled guilty. He should have tried to withdraw, and I'm sure Mike Schwartz talked to him about this. I'm sure Mike said, Larry, if you're so unhappy with me, if you're so unhappy with what we're doing here, let's try to withdraw our plea. That's step number one. If Judge McLaughlin did not let him withdraw his plea, then Michael Schwartz would have said, all right, step number two is let's challenge everything in the sentencing hearing so we can preserve all the issues for appeal. Step number three, and Michael would have said this, is Larry, fire me, hire an appellate lawyer. There was no appeal taken.
All right. We have very little time left, but I am curious as to whether you think this was a good move. I mean, should we be rehashing this as a community again? Or in your opinion, would you have advised him to lay low and come back at a later time?
Look, again, I have respect for Julie Morrow, the attorney. I'm not going to put myself in her shoes. My fundamental feeling with all of my clients is once your case is over, let it lie, because the only thing that filing something else does is bring it back up into the attention of the public. And here we are, Lynn. We're in front of the public again talking about Larry Mendte. Absolutely.
Now, some may say that that's exactly what he wants, but with these other lawsuits that are pending, some have to question if this will actually help him.
Yeah,
I guess we'll see.
The civil lawsuits can absolutely use everything he's written here.
All right. Well, we certainly appreciate you giving us your analysis of this. We do appreciate it. And of course, if you'd like to tell me what you think about this latest development in the Larry Mendte Alicia Lane saga, you can email me at tcn_iyc@cable.comcast.com. You can also find me on Facebook. Tell me what you think. Until the next time, my thanks to my crew and to you for watching. We'll see you here on the Comcast Network the next time.